Mr. Skelton?
So, thanks. So before I start, it may help if I make clear that for the most part, this oral opening statement follows the structure and content of the MPS's written opening, which I know you have. However, it does omit several quotations and in a few key respects advances some additional points.
Yep.
So this is the third phase, P3 of the inquiry's first tranche, T1, in which it will hear evidence from some of the SDS's managers during the years 1968 to 1982. This period includes the establishment of the SDS on the 30th of July 1968 in response to the Grosvenor Square demonstration against the Vietnam War on the 17th of March 1968, and its evolution into a long-term secret MPS special branch, which I will call MPSB unit, for gathering intelligence on a wide range of public order, subversion and interrelated issues. It also includes the first use of the identities of deceased children by undercover officers, who I will call UCOs, in the SDS, the first inappropriate sexual relationships by UCOs, and the first engagement of UCOs in criminal activity and the criminal justice system. So the MPS has previously set out its position in respect of all of these issues, together with wider generic themes: what went wrong, what has changed, in its opening statements for T1P1 and T1P2. It has also apologised to the women who were deceived into sexual relationships by undercover police officers and to the families of those whose children's identities were used by the SDS. And so those apologies are affirmed again now. The focus of the written and oral statements for this phase is not, however, on the substantive issues that arise within T1, rather it's on the process and scope of the inquiry's investigatory work. First, for the inquiry to fulfil its terms of reference to examine the motivation for undercover police operations in practice, and to make findings in respect of the justification for the SDS's work, it must obtain witness evidence from officers who served in the two bodies for whom the SDS primarily gathered intelligence. First, A8, Uniform Branch, which was responsible for public order policing, and second, the Security Service, which was responsible for protecting the UK from subversion. It should also obtain from former officers who served in evidence from former officers who served in C Squad, the MPSB unit, which was the principal conduit of SDS intelligence, and which directed the general focus of the SDS's work, collected and assessed its intelligence reports, and disseminated to A8 and the Security Service the intelligence which they required. Some of this work has begun, but more so is needed. Second, as the MPS made clear in its opening statement for the T1P1 hearing in 2020, it is essential that the inquiry explores and understands the historical, political and policing context of the work of the SDS as it evolved throughout the 1970s and thereafter. As the MPS went on to say in its second opening for the T1P2 hearing in 2021, this understanding must be based on evidence, not submissions, and can best be achieved by calling independent, neutral expert witnesses to give evidence at the public hearings. Third, the inquiry should provide details of any relevant reading of open source material that you, sir, have read during your appointment. Any such information, particularly background and contextual evidence, should be ventilated openly and, where necessary, tested publicly. Fourth, the inquiry should ensure that its investigation of the origins of the use of deceased children's identities is comprehensive and includes whether their use originated outside the SDS and predated its work. So finally, at the conclusion of this statement, the MPS sets out its preliminary response to the inquiry's proposal to produce an interim report and to the question of how the inquiry should approach its consideration of the laws and standards that were applicable at the time to the activities of the SDS, MPSB, the Security Service, and the government. So I turn now to the inquiry's terms of reference and list of issues. The inquiry's terms of reference direct it in part to investigate the role and contribution made by undercover policing towards the prevention and detection of crime, to examine the motivation for and the scope of undercover police operations in practice, to ascertain the state of awareness of undercover police operations of Her Majesty's government, to identify and assess the adequacy of the justification, authorisation, operational governance and oversight of undercover policing, and to investigate whether and to what purpose, extent and effect undercover police operations have targeted political and social justice campaigners. In furtherance of those terms of reference, the inquiry has published a list of issues for its investigation of the SDS in Module 1, and that comprises the examination of the deployment of SDS undercover officers in the past, their conduct and the impact of their activities on themselves and others. And it includes general questions relating to the targeting and initial authorisation and the prevention and detection of crime, and focus questions relating to the justification and value of any UCO reporting on justice campaigns, the Stephen Lawrence campaign and Dwayne Brooks OBE, elected politicians, political organisations and activists, trade unions and trade union members, social and environmental activists. For Module 2A, which involves managers and administrators from within the undercover policing units, the inquiry has published a list of issues which contains similar questions, together with a further question relating to what, if any, processes were in place to review the ongoing justification for deployments, and a set of specific questions relating to the relationship between the SDS and the security service. Similar questions have been included in the inquiry's draft list of issues for Module 2B, which was published for consultation purposes on the 19th of April 2022. So the MPS recognises the importance of these issues. As it stated in its first opening statement in 2020, it also accepts that questions over whether specific deployments and actions occurred or were justified will depend on the facts in each case. It follows that they can only be answered once those facts are known. The MPS will scrutinise all the evidence that the inquiry obtains, and to be clear, it will not seek to justify the indefensible and will acknowledge failings where it is appropriate to do so. But as I will now go on to explain, its present concern is to ensure that those matters are properly investigated by this inquiry so that any resulting findings are reasonable, fair, and properly contextualised. Before doing so, may I sound a note of caution on behalf of the MPS in respect of the reliance being placed in the opening statement of the Category H core participants on the judgment of the Investigatory Powers Tribunal, the IPT, in Kate Wilson's case. That judgment focused on the deployment of one officer, Mark Kennedy, in a different policing unit, the National Public Order Intelligence Unit, over 20 years after the T1 period. The tribunal's judgment on the legality of that deployment and the concessions made by the NPCC and the MPS on that issue are obviously instructive, but they should not be seen as establishing sweeping legal principles which render all public order and subversion-related undercover deployments wrongful or unlawful over a 50-year period. On the contrary, sir, the judgment is, as the tribunal itself recognised, fact-sensitive. And although this inquiry is not determining questions of legal liability, it will need to establish the relevant facts for itself and thereafter to make its own evaluation of them by reference to the principles and standards that have been set out transparently so all participants are aware of them. So I turn now to the responsibilities of MPSB. As the inquiry's focus has turned to the management of the SDS in the period 1968 to 1982, so greater attention is now being given to the relationship between the SDS and MPSB, the relationship between MPSB and the MPS more widely, the relationship between MPSB and the security service, the respective responsibilities of MPSB and the security service, and the role and responsibilities of central government, in particular the Home Office and the Cabinet Office. The inquiry has designated many of these issues to its Tranche 6 and Modules 2B and 2C, and the MPS is reassured that it now appears to be accepted that investigation of these issues is a necessary part of the evaluation of what was happening on the ground within deployments. Exploration of these issues is essential to meet the terms of reference, not just the element asking about awareness outside the police, but also to fairly assess the contribution made by undercover policing, the motivation for it, its justification, and its oversight. This is as true for the fair assessment of the SDS in the 1968 to 1982 period, Tranche 1, as it is for other parts of undercover work allocated to other tranches. The work of MPSB, like that of all police special branches, was directed towards public order policing and the provision of specific assistance to the security service. These responsibilities were set out in the terms of reference, prepared in collaboration with the security service and other interested parties, and agreed with the Association of Chief Police Officers of England and Wales, ACPO, in 1970. Under the heading Function, these stated, special branches responsible for acquiring security intelligence, both secret and overt, A, to assist the Chief Officer in the preservation of public order, and B, as directed by the Chief Officer, to assist the security service in its task of defending the realm from attempts at espionage and sabotage, and from actions of persons and organisations which may be judged to be subversive of the security of the state. The wording of the second of MPSB's responsibilities echoes that of the Security Service's then charter, the 1952 Maxwell 5 Directive. And I'll read a small portion of that. The Security Service is part of the defence forces of the country. Its task is the defence of the realm as a whole from external and internal dangers arising from attempts of espionage and sabotage, or from actions of persons and organisations, whether directed from within or without the country, which may be judged to be subversive of the state. The 14 specific tasks of Special Branch from 1970 include at Section 3, A, to provide the Chief Officer with intelligence affecting public order, and on behalf of the Chief Officer of the Security Service, with intelligence affecting national security. D, in consultation with the Security Service, to collect, process, and record information about subversive or potentially subversive organisations and individuals. F, to investigate any subversive background to, and this word I think is illegible, something demonstrations and breaches of public order, and in consultation with the Security Service to certain industrial disputes. The terms of reference go on to state, it is important that special branches should have a clear idea of what constitutes persons and organisations which may be judged to be subversive of the security of the state. Broadly speaking, these are any organisation or individual whose purpose is the undermining or overthrow of the established democratic order. So it is clear from the written opening statements of counsel to the inquiry and from counsel for several non-state court participants that critical questions arise as to what constituted subversion for the purpose of the Security Service, the UK government, the Metropolitan Police Special Branch in the 1960s and the 1970s. Were the individuals and groups on whom intelligence was gathered reasonably judged by MPSB, by the Security Service, or by the UK government to be subversive or potentially subversive at the time by the standards of the time? Or were they reasonably judged to present a threat to public order at the time by the standards of the time? Or, if they were reasonably judged to be subversive or to present a threat to public order, was there sufficient justification for gathering intelligence on them by means of undercover deployments? So answering these questions requires careful consideration of what was happening socio-politically 40 to 50 years ago, and of the values and the views of the government, the public, and the police at that time. As counsel for several non-state court participants also rightly point out, these questions also engage important issues as to the proper role and limits of the state in protecting its citizens and itself from harm, and the proper place of the police in assisting with that protection. The MPS doesn't seek to evade these questions or the answers they may produce, but its concern, as throughout the inquiry, is to ensure that to the extent that they are looked at, this is carried out fully, fairly, and neutrally. In short, this means that appropriate evidence must be sought and tested. The first type of evidence that the inquiry should seek is historic documentation relating to the government's interest in subversion and public order.
Forgive me a moment, someone trying to enter the room. Ignore my signal, please.
Thank you, sir. I'm glad it wasn't me. At this time, as now, the Security Service operated under the supervision and direction of the Home Secretary, who in turn was answerable to the Prime Minister and their cabinet. However, like other agencies in Whitehall, its lines of reporting were complex and subject to change. In 1972, for example, it produced a report on subversion in the UK 1972 for the Cabinet Secretary, Burke Trend, at the behest of the Prime Minister Edward Heath, and later took part in the new interdepartmental group on subversion in public life. Notably, this was chaired by James Waddell, later Sir James Waddell, the Deputy Under Secretary of State at the Home Office, who from 1968 to 1964 was also personally responsible for approving the SDS's annual Home Office funding. The group's attendees included the Deputy Assistant Commissioner for MPSB and officials from the Security Service, the Cabinet Office, the Foreign and Commonwealth Office, as it then was, the Scottish Office, and the Department of Employment. Many of the interdepartmental group's reports and minutes, together with associated correspondence and memoranda, have now been declassified and are publicly available at the National Archives in Kew. Other classified documents may be directly available to the inquiry from the Cabinet Office or other government departments. These documents, sir, are directly relevant to any understanding of the government's interest in and monitoring of subversion and potential subversion in the 1970s, including through the work of the SDS. Further documents may also be available that demonstrate the government's interest in public order issues throughout the T1 period. Where the MPS is located and holds copies of relevant documents, these will of course be provided to the inquiry. However, these are not MPS documents, and the MPS has no more access to them than the public. And of course, not all of the documents are publicly available at Kew or elsewhere. Therefore, the inquiry is invited to exercise its powers, its statutory powers, to obtain all relevant documents directly from the Cabinet Office and the government. The second type of evidence that the inquiry should seek is witness evidence. 13 former SDS managers from the 1968 to 1982 period have provided witness statements to the inquiry, of whom 7 are providing evidence at this public hearing. Their evidence makes clear that the SDS worked in furtherance of MPSB's responsibilities for its 2 primary intelligence customers, A8, the uniform branch of the MPS, responsible for public order policing, and the Security Service. The former, like the SDS, was set up specifically in response to the Grosvenor Square demonstration on the 17th of March 1968. For most of the 1970s, the MPSB unit with primary responsibility for meeting the intelligence requirements of A8 and the Security Service was C Squad, which specialised in intelligence on domestic extremism, communism, and subversion and public order. The SDS was originally an independent unit within MPSB, sitting outside the operational squads A, B, C, D, E, and P reports. However, from late 1972 or early 1973, it became part of C Squad, and from July 1974, it was part of the newly created S Squad, which was formed to coordinate the various technical and support functions performed by Special Branch. So this is relevant to any understanding of the SDS's role and how the squad sat within MPSB's wider work. C Squad officers are also directly answered the Security Service's specific requests for information and disseminated hundreds of relevant SDS intelligence reports to them at Box 500. The magnitude and the unremitting nature of C Squads and the MPSB's work for the Security Service and for A8 is illustrated by a memorandum written by Commander Rollo Watts following a meeting between MPSB and the service on the 11th of October 1976. And this states at paragraph 3, I quote, Chief Superintendent R. Wilson then spoke about manpower difficulties on his C Squad. Theoretically, 60 officers, usually reduced by other commitments to about 30 at any one given time. Despite this, however, between 250 to 300 inquiries were completed for Box 500 every month He stated, however, that he was bound by the primary objectives of the police service to give priority to inquiries which related to matters of public order. Mr. Watts emphasised this point by explaining that special branch were responsible for something in the region of 600 to 700 pre-demonstration assessments every year for the information of the uniform branch. It's clear from the manager's evidence that the SDS did not set the intelligence requirements that drove the tasking of its undercover deployments, nor, for the most part, did it pass intelligence directly to its ultimate customers. This process was directed and mediated primarily by C Squad, based on the requirements of A8, public order, and the security service, subversion, etc., and the MPSB B Squad, Irish nationalism. Within C Squad in the early 1970s, detective inspectors occupied specific posts relating to the security service, the ultra-left, special demonstrations, and the Communist Party. The SDS also didn't assess, in the formal sense of collate and analyse, the intelligence that its officers gathered. Intelligence relating to public order was disseminated elsewhere for analysis and action. For example, it was converted by C Squad into sanitised pre-demonstration assessments, which I've referred to, also known as threat assessments, for the benefit of A8, although urgent public order intelligence could be telephoned directly to A8 at a high level. Intelligence relating to subversion was passed by C Squad in its original unsanitised form directly to the security service. And in respect of the specific intelligence work undertaken by the SDS between 1968 and 1982, the task of producing a comprehensive, objective assessment of its justification and value on a granular level, deployment by deployment or report by report, is impossible. The exercise of asking the undercover officers, their managers to do so 40 or 50 years after the index events is inherently problematic and unfair. The events are too long ago, and the causative pathways and the counterfactual scenarios are too obscure and too complex. Any attempt to assess the justification and the value of intelligence retrospectively would be an exceptionally difficult task. This is partly because intelligence work may be justified because intelligence that was collected had a latent or potential value, but this value never subsequently materialized. For example, details of a plan to create public order which did not occur, or the name of an individual who associated with a dangerous anarchist group, but who left and was never heard of again. It's also because knowledge of subsequent events inevitably colours the evaluation of earlier events. To take an obvious example, it's now known that none of the groups which advocated the end of capitalism or democratic society in the 1960s or the 1970s came close to succeeding in their aims. And so governmental and police interest in them at the time may, to modernise, appear alarmist or anti-democratic or quaint. But if notwithstanding these points, the inquiry does intend to make findings about the justification and the value of SDS deployments in the T1 period, then in the interest of fairness, the inquiry must provide the core participants with a clear indication of how it intends to approach these matters. This must be given in advance of the closing stages so that proper consideration can be given to the question of whether sufficient evidence has been sought. The inquiry should indicate the level of granularity at which it proposes to make findings about value, justification, or authorization. For example, whether it proposes to make findings about the value of deployments into specific groups, or reporting on specific individuals, or reporting on specific events, or reporting of specific types of information during the T1 period. The inquiry also needs to set out transparently for all core participants the test it will apply and the factors it will consider to be relevant to establish value and justification. Where these may be contentious or involve questions of law, these matters should be decided by the inquiry only after hearing submissions from the core participants. Additionally, sir, for the inquiry's findings on these issues to be fair, it must ask former officers of MPSB C Squad, A8 Uniform Branch, and the Security Service directly to explain the justification for seeking intelligence on those groups and individuals, and what value the resulting intelligence had to their work. They should also explain why intelligence needed to be sought using undercover deployments rather than by some other means available to them. For example, open sources such as public meetings and publications, or alternative closed sources such as informants and surveillance. Those critical questions cannot be answered definitively and fairly by the STS's former managers, as they themselves have said, and to rely on their opinion evidence alone, alongside the available documents, would lead the inquiry into error. That is particularly so given that highly relevant contemporaneous documentary evidence, specifically STS reporting on public order that was not passed to the security service, and pre-demonstration reports or threat assessments produced by MPSB for the benefit of A8 haven't been located. It is understood that the inquiry is now intending to obtain witness evidence from former managers in MPSB C Squad, and this is welcome. And the MPS will do everything it can to facilitate the provision of this evidence to the inquiry and has already identified some potential witnesses to the inquiry. The evidence they produce will be of limited value, however, if the inquiry doesn't at the same time seek and obtain evidence from those on whose behalf C Squad gave overall direction to the focus of STS infiltrations and collected and assessed and distributed the intelligence it gathered. Evidence points to the fact that C Squad was a conduit between the STS and its ultimate customers, and that it deliberately kept the STS in the dark for the sake of protecting its UCOs about intelligence it received from other sources, including the security service. In the case of the security service, more is needed than a composite corporate statement from witness Z, who has no direct experience of any of the events in question. Unsurprisingly, such evidence is of limited value. For the reasons I've given, it is vital that the inquiry gains a proper and full understanding of the role and responsibility of the security service, its position as the link between the government and MPSB, and its relationship with MPSB. Therefore, statements should be sought from contemporaneous officers who requested intelligence from MPSB on subversion or security-related matters, assessed the resulting product, and reported directly to the government. The government, through the Home Office and the Security Service, required the MPSB and the STS to obtain intelligence on particular groups, movements, issues, and individuals. This should be made clear in witness evidence, so the inquiry can fairly assess the justification for the STS's work and its resulting value. If the inquiry intends to find that the specific aspects of the STS's work were not justified or valuable, then these criticisms must be put to those people and bodies who requested, relied on, and or funded the STS's work, not simply the STS officers themselves. The inquiry will no doubt wish to consider carefully to whom it must in due course give the opportunity to respond to such criticisms during the warning letter process for its interim or its final reports. The work of the Security Service, insofar as it intersected directly with that of MPSB and the STS during the index period, is clearly within the inquiry's terms of reference, as you, sir, have previously stated. It's not understood that the service itself has sought to argue otherwise. The investigatory requirement for proper witness evidence, which the MPS first identified in its opening statement for T1P1, is therefore obvious and unanswerable. And further, there are no procedural reasons why such statements should not be sought. Former security service officers are former servants of the state, and so no different from former undercover police officers and their managers. If their evidence is relevant and necessary, then it should be obtained without fear or favour. Finally, sir, in respect of additional evidence, the inquiry must contextualise the work of the STS by reference to the historical, political, legal and policing circumstances of the time. Only by doing so can the reasons for the government's and the Commissioner's interest in public disorder, industrial unrest and subversion be properly understood, together with the MPS's and the security services resulting requirements for intelligence relating to those matters and the decision to use undercover deployments to obtain that intelligence. None of the witnesses called during Tranche 1, including the civilian witnesses and the former STS officers and their managers, have been able to provide independent, impartial, or comprehensive accounts of the wider national or metropolitan context in which their actions and experiences occurred. nor could they have been expected to do so. They were personally involved in the specific events under scrutiny, either as STS officers or as civilians who featured in the STS's reporting. Additionally, and understandably after 40 to 50 years, some witnesses' accounts are incomplete or entirely at odds with those of other witnesses, or unanswered by potentially relevant countervailing evidence. If it doesn't properly embed its findings within that complex history, there is a real danger that the inquiry, in good faith but inadequately, will assess complex events by reference to a small number of opposing accounts. Obvious but important questions which are needed to make sense of the historical concerns and decision-making and relevant to the assessment of the STS's work have not yet been fully and independently answered. Such questions include: 1, during the period 1968 to 1982, what public disorder was occurring in London and elsewhere in the UK? 2, what was its cause? 3, which groups, movements, or issues were involved? 4, which groups, movements were seeking to cause public disorder? 4, which groups, movements were seeking to undermine the security of the state? 6, did the government and other state institutions, including the police, judge those groups or people associated with them to present a threat to public order or the security of the state? In the MPS's oral opening for the T1P2 hearing on the 21st of April 2021, it urged the inquiry to contextualise the evidence under scrutiny using written and oral evidence from a suitable academic historian. Its submissions on this issue are quoted in full at paragraph 42 of the written opening by the MPS for this hearing. So during the Bloody Sunday inquiry, the tribunal commissioned expert reports from 2 historians of Irish and Northern Irish history, Professor Paul Bew and Professor Paul Arthur. Their evidence, together with open source material, read and disclosed by the tribunal, formed the basis for the detailed, neutral, historical narrative with which the inquiry contextualised the events on the 30th of January 1972 in its report. Such evidence was obviously important to an inquiry in which, as in this inquiry, national history itself was relevant and under scrutiny. One of the primary tasks of an expert witness would be to adduce at the public hearings relevant evidence about which none of the existing factual witnesses can speak with authority or independence. And this would include introducing the objectives and activities of the various groups and factions that were involved in demonstrations in London, or were judged to present a threat to the security of the state during the 1970s, such as the International Socialist / Socialist Workers' Party, SWP, and the International Marxist Group, or IMG. This could be done by reference to contemporaneous material, not as yet considered openly by the inquiry, such as the Socialist Worker newspaper, which, as one historian noted at the time, had a section entitled "Where We Stand," in which the SWP set out its calls for mass action by the workers to seize control of the wealth created by them under capitalism and to destroy the system. Another important task of an expert witness would be to identify the scope of the MPS's responsibilities and to explain, 1, how public order policing was undertaken at the time, and 2, how intelligence work was conducted in the 1960s and 1970s, including how operations were planned and how intelligence was collected, assessed, shared, and filed. Such evidence is essential for a fair assessment of the STS's work, as other inquiries have recognised. Most recently, the Brooke House inquiry has commissioned and heard evidence from 3 expert witnesses during its investigation of the mistreatment of individuals detained at the Brooke House Immigration Removal Centre. This includes evidence on the legislative and policy context of the use of force in detention centres, its governance and oversight, and the professional standards applicable at the time of the index events. In their opening for this hearing, the Category 8 core participants and others have raised serious questions about the lawfulness, necessity and proportionality of the STS's work during the T1 period and subsequently. The inquiry is charged with making findings of fact, not determinations of civil or criminal liability, which are precluded by Section 2.1 of the Inquiries Act 2005. But the MPS welcomes focus on the contemporaneous legal framework within which the STS, MPSB and the Security Service and the government operated, which must, again, be assessed by reference to the values and standards of the time. And I will return to this issue at the conclusion of the statement. One of the tasks of an expert would be to introduce evidence for which there is no surviving factual witnesses from the time. An example of this is an article on public order policing in July 1975 in the edition of the Police Journal by the then Commissioner, Sir Robert Mark, that called the Metropolitan Police and Political Demonstrations. This provides a high-level commentary on the complex task of policing political demonstrations in London in 1975 and includes statistics relating to the preceding 3 years. It was first published as Appendix 8 to the Commissioner's 1975 annual report, which covered the MPS's work in 1974. All the Commissioner's annual reports for the period 1968 to 1982, together with MPSB's annual reports, have been provided to the inquiry. They are a valuable source of information and evidence about which the MPS's work throughout Tranche 1 cannot properly be understood. It is all the more important that such documents are introduced into evidence and contextualised by a historian, given that Sir Robert Mark and both his predecessors and successor from this period, Sir John Waldron and Sir David McNee, are dead. So too are the officers at the rank of commander and above who directly oversaw the work of the STS during this period. None of them can now be witnesses to this inquiry. The MPS isn't seeking to nominate specific experts to provide evidence. That is a matter for the inquiry, assisted by submissions from the core participants. However, several potential witnesses exist. One is Christopher Andrew, who is the author of several books on the history of intelligence gathered in the UK, including The Defence of the Realm, which counsel to the inquiry quoted from earlier. Other potential candidates are Richard Aldrich or Rory Cormack, who are co-authors of The Black Door, Spies, Secret Intelligence and British Prime Ministers. Both of these publications contain meticulously researched accounts of the government's concerns about left-wing subversion and the associated issue of unrest throughout the 1970s and its resulting efforts to monitor the threats these were thought to present at the time. The MPS urges the inquiry to reconsider the appointment of one or more historical and professional experts. It would be most unfortunate if an inquiry of this breadth and importance didn't ensure that the scope of its public work included proper contextual evidence. Such evidence is important procedurally, in addition, for two reasons. First, the expert will be able to draw on any and all relevant material available from public open sources or through the inquiry. The scope of that material will be much wider than the narrow categories of documents and other material that have been adduced in the bundles for the inquiry's witness hearings. This will reduce the burden on the inquiry and its core participants to seek out and review such material. It will also ensure that the sources ultimately relied on by the inquiry in its reports are as comprehensive and as balanced as possible, and as importantly, that they are clear to the participants and the public. Second, the expert's evidence will provide a clear structure to the inquiry's consideration of the historical events and practices under scrutiny. At present, it is not fully apparent how the inquiry is investigating the wider socio-political, policing and national security context of the time, what sources of information it is being based on, or how it intends to construct a narrative out of its investigations. Evidence from an expert would provide a means of clarifying each of these matters fully and openly. It would identify key facts, policies, and other considerations in a neutral and independent way. These could then be probed and tested during the oral hearings, commented on in the core participants' closing submissions, responded to as necessary during the warning letter process, and of course, ultimately relied on in the inquirer's reports. I turn now, sir, to the reading that has been done by you as chairman. It is clear, sir, that you have read open source material which provides information that is relevant to the events you are investigating. And this includes some or all of the Defence of the Realm and the book In the Office of Chief Constable, the autobiography of Sir Robert Mark, who was Commissioner from 1972 to 1977. It may also include The Black Door that I have just mentioned and publications on the history of Trotskyism. The very fact that this reading has been necessary supports the MPS's position, which I've outlined, that this inquiry requires contextual evidence, albeit that such evidence should be adduced publicly, not privately. The MPS and the designated lawyers have asked the inquiry what background reading you have undertaken in respect of issues which may bear upon the inquiry's terms of reference. The inquiry has not as yet provided an answer to this question, and so this is unfortunate because the issue is important. Section 18 of the Inquiries Act provides that, subject to any restrictions imposed by a notice or order under Section 19, the chairman must take such steps as he considers reasonable to secure that members of the public, including reporters, are able, B, to obtain or view a record of evidence and documents given, produced or provided to the inquiry or inquiry panel. So if you have read books, scholarly articles or contemporaneous documents that provide information about the issues that are within the inquiry's terms of reference, then this should be disclosed to the core participants and the public. The relevant material should also be identified and, where possible, published so that it can be referred to as necessary in witness questioning, submissions, opening and closing statements, and in due course responses to warning letters made pursuant to Rule 13 of the Inquiry Rules 2006. This applies to all relevant material that has been considered, not just material upon which the inquiry intends to rely in its reports. If the inquiry does not publish your reading, this will impede the core participants' understanding of and engagement with the inquiry's investigatory work. They will remain ignorant of information that may elucidate matters that are under investigation directly or by way of general context. As importantly, there is a real risk that the inquiry's conclusions will be informed by and based on factual assertions and viewpoints that are unknown or untested or controversial or wrong. And this would undermine public confidence in the inquiry and the fairness of its findings. For these reasons, the MPS respectfully repeats its request that the inquiry clarifies these matters. The final matter, sir, that I'd like to address today is the origins of the use of deceased children's identities. The MPS has apologised for the hurt caused by the use by the SDS of the identities of deceased children, and it maintains that apology. The Module 1 Special Demonstration Squad issues list includes the following questions about the origins of the practice of using deceased children's identities under the heading Legend Building. Question 19, when and why did the practice of using deceased children's identities begin? Question 20, who devised and or authorised the practice? The answers to these questions are important to the MPS and to its former officers. They're also important to the inquiry's other core participants, including those in Category F, and to the public, given the national media coverage of the issue and the finding of the Home Affairs Select Committee 2013. They should therefore be important to the inquiry. If the practice of using deceased children's identities was first used in the UK by the SDS in the early 1970s, then that fact should be made clear. If it was first used by other state bodies, such as the Security Service, and thereafter adopted by the SDS, then that fact too is significant and should be made clear. It's the clear implication, sir, of items 19 and 20 of the issues list I have just read out that it would investigate those matters. Further, establishing when the practice began and who devised it is of obvious importance or obvious relevance to any assessment of whether its use by the SDS was standard in undercover work and or reasonable. If the origins of the practice cannot be determined at this remove, then that is also significant and should be made clear. Fairness to the SDS and its officers and managers requires that these matters are clarified by this inquiry as a matter of public record. The designated lawyer team, which represents most of the former SDS officers, wrote to the inquiry about this issue on the 18th of October 2021, and I'll quote from their letter. It has been suggested that other agencies, e.g. MI5 and the KGB, used information about deceased individuals in the creation of cover or fictitious identities, and that this may have been informed or inspired the SDS. Operation Hearn Report 1, Use of Covert Identities, July 2013, Part 4 also refers to Operation Mincemeat, The Man Who Never Was, and The Day of the Jackal. Please would you confirm if the inquiry has followed up these suggestions with MI5 or any other agency? i.e. in order to discover if the practice was more widely used, and if so, when, where, how, and by whom. If the inquiry has done this, what information was provided? And if not, please could the inquiry make inquiries along these lines? So it's understood that the inquiry subsequently confirmed to the DL that it doesn't intend to investigate the origins of the use of deceased children's identities other than by asking former STS officers about the practice. More recently, the inquiry has indicated to the MPS that it is clear from the issues list that the inquiry's investigation is confined to the use of the practice by the SDS. With respect, sir, the MPS disagrees with this interpretation of the list of issues. In short, for the reasons given, the MPS requests that the inquiry reconsider its position and investigate this issue fully, as indicated in the list of issues. There can be no good reason for not asking the Security Service whether the practice was used by its officers or agents prior to its use by the SDS. Much of the work of the Security Service and its past methodologies is now in the public domain, most obviously in the authorised history by Christopher Andrew, to which I referred. Even if the inquiry's investigations are unwelcome, or the answers to them embarrassing or sensitive, which is unlikely given their generic nature, that doesn't mean that inquiries shouldn't be made. I turn lastly to the conclusion of the statement. The core participants have now been told by your counsel in his opening statement that the inquiry will produce an interim report concerning Tranche 1, but that decisions on scope have not yet been finalised. The MPS would welcome urgent clarification of the proposed timetable for the production of this report. It would also be grateful for a clear indication of the issues that the inquiry intends to address in both its interim and its final reports, i.e. their scope, together with those it does not intend to address at this stage or is precluded from addressing by law, including matters of civil or criminal liability in respect of the actions of the SDS, MPSB, the Security Service and the government. This will enable the MPS to best assist the inquiry by way of further evidence and submissions. To be clear, the MPS's position is that it would not be appropriate or fair for an interim report to include findings about the justification and value of the STS's work in the T1 period or the provenance of the use of DCIs unless and until the inquiry has completed its Module 2B and 2C investigations and obtained the specific and contextual evidence identified in this statement, including testing it in live hearings. If this is not the inquiry's position, the MPS would be grateful for confirmation that there will be an opportunity to make submissions on these matters. The MPS submits that it is essential that the inquiry obtains and hears witness evidence in public from the STS's two intelligence customers, A8 Uniform Branch and the Security Service, and the operational squad most directly concerned with its work, MPSB C Squad. It also repeats its request that the inquiry call expert evidence, which places the STS's work in its proper historical, political and professional policing context, and its request for the inquiry to properly investigate the origins of the use of deceased children's identities. So if you are not minded to accept the MPS's submission on these issues, then may I formally request that you provide a written ruling setting out your reasons for rejecting them. Finally, the MPS would also be grateful for clarification by the inquiry of the test or standards that it intends to apply when assessing the justification and value of the STS's work in the period 1968 to 1982. This includes the applicable legal principles and standards governing the activities of the SDS, MPSB, the Security Service, and the government. As I have said, the MPS welcomes consideration of these issues, which it has itself been considering and which have now been brought to the fore by the opening statements of the Category H core participants and others. No doubt, in the normal way, counsel to the inquiry will ask questions which bear upon these issues during the forthcoming hearing, including whether the SDS managers considered the lawfulness of their work at the time and whether advice was sought on that question. Of course, such questions will also need to be explored with Module 2B and 2C witnesses before conclusions can be fairly drawn. However, it needs stating that because public inquiries are inquisitorial, not adversarial, it's not for one set of participants to set out submissions on the law and allegations on the facts for other participants to be required to respond to those submissions and allegations, and for the tribunal passively to receive them and to hand down judgment, as would occur in a trial in a court. This is also because, as I've said, the inquiry must not rule on and has no power to determine any person's civil or criminal liability per section 2.1 of the Act. So to conclude, the MPS must take the lead, the inquiry must take the lead now and set out in writing the issues that it proposes to address in its interim report and the legal framework and standards that it intends to apply in reaching its determinations. The MPS respectfully suggests that a timetable should also be set for written submissions and relevant evidence from the core participants in response to the inquiry's proposals, together with an oral hearing if necessary. In this way, the core participants, including the MPS, will be best placed to assist the inquiry in its consideration of these important matters. So in closing, I would like to reaffirm the assurance the MPS has given in this statement that it will not seek to defend the indefensible. May I also repeat the assurance that the MPS has given previously that it will continue to participate fully in the inquiry's work and to do so with openness, transparency, and a willingness to improve. Thank you.
Thank you very much, Mr. Skelton. I'm encouraged by your last words. I do not intend to issue a formal written ruling in response to your submissions, but I propose to answer them orally now. Not in the precise order in which you've raised them, but in an order which seems to me to make sense. First of all, you submit that I need the advice of one or more historians to inform me about historical, social, and political events and the circumstances in which policing was undertaken in the period from 1968 until, in the case of the SDS, its conclusion in 2008. I declined to do that for a number of reasons. First, the period under review is one during which I was throughout a sentient adult interested in political affairs. I give an example which is, as it happens, slightly before and slightly outside the period that I'm looking at, so as to avoid trespassing onto matters that may ultimately be the matter of submissions. I listened on the radio to live broadcasts of the événement of Paris in May 1968. I heard General de Gaulle's brusque speech on his return from General Massu in the French army part of West Germany. And I saw on the television the reaction of Parisian people to his speech and the events which had occurred. I was also aware of the outcome of the general election that then followed these events in France. I won't at this stage say what my reaction to all of that was, lest I betray some tendency that I should not. But you need have no concern that I am, from my own personal experience and from reading, to which I will come in a moment, aware of the political and in general social circumstances in which the events that I'm inquiring into occurred. Second reason is this: I choose two dead historians so as to avoid offending the living. But if I had commissioned reports from Eric Hobsbawm and Robert Blake about these events, I would have got two very different reports because of their differing starting standpoints. You ask about my reading. I have a library at home of over 300 volumes about modern history in the classical sense, post-1713, but almost all of them are post-1789. I do not have a catalogue of my library, and I do not intend to sit down to produce one, but inevitably I have informed myself over the years about historical events, in particular reasonably modern historical events. I suspect your question was prompted by my questions of Tariq Ali about Trotskyism, and Andreu Nin, who, as I'm sure you know, was executed, murdered by agents of the NKVD in Republican Spain when Stalin required him to be put out of the way. Now, I know about that because I read Hugh Thomas's book on the Spanish Civil War, and more recently I read Stephen Kotkin's admirable biography, as yet incomplete, of Stalin. I'm not going to announce formally that I have read these things. I deal with it by questioning somebody who knows a great deal more about Trotskyism, Tariq Ali, than I ever could hope to. So the answer to your second proposition, that I should disclose a list of my reading, is what I have read and is going to be taken into account in the course of the inquiry, certainly will be published, as it has been by Mr. Barr this morning. But I am not going to put into the public domain every bit of history that I have read that has informed my understanding of what in the general political and social circumstances of the United Kingdom, England and Wales and Europe occurred. Third, and perhaps rather more important, is the contemporaneous evidence about the receipt and the use to which it was put of SDS intelligence. Now, the best contemporaneous evidence for any historian or inquisitor such as me into what happened is contemporaneous documents. My understanding is that the A8 contemporaneous documents, the threat reports about the major disturbances that occurred in Tranche 1, cannot be found. I can't find them if the Metropolitan Police don't know where they are. And if they've gone, they've gone. As you rightly say, there is nobody in a senior position in A8 now who is alive and able to provide a statement. I very much doubt the utility of asking a junior officer at the time involved in processing the reports and sanitizing them so that they end up in a threat assessment without being capable of being attributed. I strongly doubt the utility of asking any such person. We do in fact have one or two people who fulfill that role who can be asked to the extent that they can help. Gladly, I will accept their assistance, but I am not going to go chasing around umpteen junior officers whose identities I do not know to try and find out if they might be able to help. As far as the security service goes, I am not investigating the security service. I am investigating a unit of the Metropolitan Police, as you know. The security service have provided me with a mass of documents, which I could never have hoped to get from the Metropolitan Police, which have provided invaluable information about what occurred. They've also provided a thoughtful, entirely public witness statement from witness Z. I would have no objection at all to the Metropolitan Police providing a similar statement, if, as I anticipate, they, any more than I, can not identify individuals who can provide it from their own knowledge. The next point deals with the use of deceased children's identities. It is clear that at some stage, the SDS adopted this practice, precisely when I have not yet discovered. By precisely, I mean to within a month or two. I now believe that it's possible to establish approximately when it occurred, but not certainly to within a month or two. Now, a decision must have been made within the MPS, if not at SDS managerial level, and you rightly submit there's no evidence of that, at a higher level. It must have been documented, at least I hope it must have been documented. I don't know where the documents are. If the MPS can find them, then I would gladly welcome assistance. And it is conceivable, here I'm purely speculating, that Arthur Cunningham was the source of the idea, because he was, I now know from the helpful research that's been done by the DL, in charge of the investigation into the KBG use of the identity of a dying man who subsequently was prosecuted in this country for, I think, making a false passport application. But it was clearly rather more than that, as the judge's remarks made clear. But unless such evidence can be found, I very much doubt it is going to be possible to say within the MPS who did it. I don't, in those circumstances, see the utility of asking the security service, who I am reluctant to pry into their practices, in circumstances where I have no reason to believe that they would have done, let alone SIS, who may or may not have used the practice, but as their responsibilities for gathering intelligence abroad, it couldn't possibly have any legitimate impact upon a police force gathering intelligence in this country. So the answer to that is that I do not intend to investigate whether deceased children's identities were used by others. And I can't for one moment think that you would wish it to be thought that the KGB had been the originator of the practice adopted by a domestic police force. I think the less said about that, the better. Now, there's a final issue which you haven't raised in your submissions, and I'm not expecting an instantaneous response to, but is a matter raised by Ms. Kilroy, and is one that the inquiry would ultimately have looked into, I hope, in any event. And that is the lawfulness of some of the practices adopted by the SDS. I'm not talking at the moment about sexual relationships with activists or in a false name. I'm not talking about turning up at demonstrations and participating in events that on one view amount to public disorder. I'm not talking about trivial matters such as fly posting. I'm talking about things that were actually undertaken with the knowledge of managers, and certainly without disapproval, but which raise questions as to lawfulness. And may I give the two examples that occur to me? The first is gaining entry to someone's home by falsely pretending to be somebody else. My understanding is that it has always been accepted that at common law, and here I'm concerned with common law, not the convention, but common law, that was regarded as a trespass. Certainly for the purposes of the Larceny Act, gaining entry to a home with it between 9 and 6, i.e. at night, by fraud was regarded as constructive breaking. You know, you had to break and enter to commit burglary under the Larceny Act. I have seen nowhere any suggestion that the lawfulness of that particular technique was considered at any level within the MPS. The second, slightly more arcane, is the distribution of confidential information, such as banking details, without a warrant. If it is a breach of the law, it's plainly a breach of the civil law, just as trespass would be a breach of the civil law. But on the whole, my understanding is that the police forces of this country have always sought to operate within the civil law, hence the need for warrants to perform acts that would amount to a breach of the civil law. And I would welcome submissions on that. Plainly, you're right. I'm not here to make findings about whether or not unlawful activity occurred, but I do want to know whether the lawfulness of activities were considered, and if so, what, if any, conclusion was reached about it. And if not, whether in fact these activities could properly be considered to be lawful. Forgive me for that rather long response, and of course you may, if you wish to, respond now, but you may prefer to hold your peace, and I won't hold it against you if you do.
So you've offered me a lifeline, which I'm going to take.
Right. And thank you very much for your patience. We will now break for a quarter of an hour before Mr. Sanders makes his submissions. Thank you very much indeed. Mr. Summers.
Good afternoon, sir. Thank you.
Afternoon.
This is the opening statement for the T1, P3 hearings on behalf of the designated lawyer officers, who, as you know, comprise 115 former members of mostly the Special Demonstration Squad, SDS, and also the National Public Order Intelligence Unit, NPOIU. So my clients and the members of that core participant group include the vast majority of the police witnesses that you've heard from so far and that you'll be hearing from this week and next week. So it was my intention to be quite brief in this oral statement. I may have to be even briefer now because I feel somewhat like a footballer stepping out to take a penalty, only to find not only have the goalposts been moved, they've been taken down and the ball's been taken away as well. Obviously, I'm quite closely aligned with Mr. Skelton in terms of the issues I was going to press. I don't want to take up your time unnecessarily. It's by the same token, it's quite difficult for me to extricate parts that may no longer be live, at least for yourself.
Of course, and I have no objection at all to your making submissions that have not already been made by Mr. Skelton, which you share. I understand that you share them. If you want to say anything additional, then please do. My mind is obviously not closed until after I've heard everybody, however firmly I may have expressed my opinion.
Yes, I can. I'm not sure Mr. Skelton will feel very good about it if you suddenly change your mind after hearing me say exactly the same things, but I'll press on nevertheless. So in our written opening, we'd touched on three more substantial evidential issues and then three more miscellaneous matters. I'm going to follow that outline and then touch briefly on the issue that you've raised in relation to Ms. Kilroy's submissions on lawfulness and legal framework and so on. The first evidential issue, sir, is just in relation to modules 2B and C. So that's the evidence from senior personnel above the SDS and also other personnel working with and around the SDS. In our submission, it's important that this evidence is heard before you sit down to finalise any interim report on the T1 period. Nothing you've said or what Mr. Barr said suggests you're minded to do otherwise, but that's very clearly our position. The importance of evidence from and about the A8 Uniform Public Order Branch, the C Squad and the other Special Branch Squads, and also MI5 is in relation, we submit, to the justification for the SDS reporting. And in order to assess, make findings about the justification issues, we say you need to hear evidence about the setting of specific intelligent requests, so particular requests that were sent to Special Branch and then passed on to the SDS to answer, and also the setting of general intelligence requirements to cover particular areas or particular groups or particular individuals. Also important evidentially is the use to which intelligence obtained by the SDS was put. That intelligence obviously went into individual intelligence reports. It went into other oral and written communications, and it went into ultimately the general resource of the Special Branch registry. So anyone referring to registry files would be referring or could be referring to, amongst other things, intelligence obtained by the SDS. And then the intelligence was also fed into threat assessments that were passed to A8 by the Special Branch squads. I've heard obviously what you've said to Mr. Skelton about the difficulty of obtaining evidence in relation to those matters, and pleased to hear that there are some names that you have that you may be able to follow up. I think talking talking generally to my clients, there should be evidence out there about threat assessments, how they were formulated, what purpose they served. We've got some quite tangential evidence from Christopher Skay, who obviously went on to work as the Special Branch Liaison Officer in A8. And in our submission, there should be other people still available to give evidence about that, and about liaison between first the SDS and the MPS squads, and then secondly, the liaison between the MPS squads and both A8 and MI5. You, of course, have already obtained quite a lot of evidence about direct liaison between SDS and MI5 on a separate dotted line, as it were. One important thing to bear in mind in this regard is that, of course, consumers of SDS intelligence were not always conscious of the fact that they were consumers of SDS intelligence, either because it went to them in a sanitized format or because they were simply referring to materials or making inquiries of the Special Branch Registry. So there are, of course, difficulties in that regard, but we submit that it is important to try, as far as possible, to obtain evidence from witnesses able to speak directly to those matters. Because otherwise, what you're left with is a focus on the SDS as either the antenna or the pipe collecting this information and passing it up the chain, but no evidence about what happened to it, which must be crucial to any assessment of its value and utility. So far as concerns MI5, we say there are limitations to the statement of witness said, in that it's second-hand evidence, it's crafted to be open-only evidence, and so therefore does deliberately refrains from touching on closed matters. It's very much focusing on the relationship, the direct relationship between MI5 and the SDS, and has very little about the relationship between MI5 and Special Branch and the Special Branch squads, and nothing about the correspondence passing between MI5 and the squads. And in our submission, that's quite important contextual information. One has seen a reasonable proportion of the intelligence reports attributed to the SDS, beginning with a cross-reference to a Box 500 inquiry, and effectively that report is then answering that inquiry. We have seen very little. I can think of only a couple of examples, possibly in relation to closed offices, where we've seen the letter from Box 500 to the squad, and then that's then generated the intelligence report containing the answers. All of that in our submission is not in the statement of witness Z, and it would be helpful to get some more evidence, if possible, about it. There's also nothing in witness Z's statement about vetting. And of course, witness Z, he or she, is not giving any closed evidence and not giving any oral evidence. So for those reasons, and for the reasons elaborated on by Mr. Skelton, we do say that more evidence is important in terms of modules 2, B and C. Collecting it before any T1 closing statements and interim report is important. And in our submission, that should be done or should include live evidence dealing with those matters. So my next topic was under the heading Other Available Evidence, where we, of course, closely aligned with Mr. Skelton in relation to the need for an expert historian or historians to give evidence about political and socio-economic context. We've also made the point that it would assist you, sir, to have some evidence from clinical psychologists or behavioral scientists as to the way in which human beings respond to long-term undercover deployments and to living second fictitious lives. evidence explaining what one can expect from human beings in those circumstances, what attributes would make someone suitable for that work or unsuitable for that work, and the stresses it involves, the risks that it may carry, and the best way to manage those risks. That's a further area where we say you should obtain evidence, and we are aligned with Mr. Skelton in relation to your background reading. I heard obviously your response in relation to expert historical evidence, and in relation to your background reading. The difficulty with the approach that you're taking is that in some senses you're almost treating yourself as a witness, to say, well, I was a sentient adult at the time, I witnessed these events unfolding on television and radio, read about them a great deal. The difficulty with that, in my submission, is that none of the core participants can propose questions to be put to you about that, and counsel to the inquiry won't be able to put those questions to you. So you also alluded to having opinions about matters that you perhaps wouldn't want to share at this stage, or it wouldn't be appropriate to share. It's important in my submission to, of course, you have your own knowledge and your own experience, and that's perfectly understandable, but to have someone independent of yourself and of all the core participants speak to these matters and give evidence, because obviously you can't give evidence, you can't be a witness, and to allow for that evidence to be questioned is an important part of the process. So we would urge you to reconsider that. I take the point about you not wanting to catalogue your library, but some indication of what you see as the key texts that you've read. From my perspective, events in France and Spain and so on seem fairly peripheral, but there must be books in your library which really speak directly to the matters of relevance to this inquiry, that it would be helpful to know that you've read them. It may be, we don't know, that one of the core participants may be able to suggest, well, if you've read that book, you must read this one, or you must bear this point in mind when it comes to chapter 3 or something like that. So all of this is just about transparency and allowing all of the core participants to participate in the process, address you and put questions to witnesses who can give evidence. I also note that you don't intend to give a written ruling about this, but I would urge you to provide some guidance in writing for the core participants as to your approach and your reasons, so that they can be considered and understood. So the third evidential matter that I just wanted to address you on briefly is in relation to the use of deceased children's identities. And I've heard what you've said about that today. And of course, Mr. Barr addressed you on it this morning. Well, possibly it was just before lunch, but I understand your position. The reason we say you should and you must go wider than the SDS and its use of information about deceased children and deceased young adults in constructing or in forming the basis for undercover identities is that it's vitally important to meeting the issues outlined in the issues list. One narrative about this matter, and particularly you'll see this in the category F core participants submissions, is that the SDS use of the practice, of the tactic, was potentially plucked from popular culture, was an instance of isolated, aberrant thinking, characteristic of a unit that's gone off the rails, and that no one else did such a thing or would have done such a thing because it was so obviously unconscionable and disgusting, and also that other alternatives were available. It's clear in our submission that the idea didn't come from the day of the jackal, and as you've seen from our written statement, we in fact spoke to Frederick Forsyth, who explained that he heard about it from a mercenary he'd met while covering the Biafran War. It was the way in which, at that time, pre-computerization, a false British identity was constructed. Mr. Barrs recognised that it was used by others. You've referred to the Malvina prosecution, which was obviously brought to our attention by Geoffrey Craft, who was involved in the case, and that culminated in an editorial in the Times highlighting the fact that there was a loophole in the system, in that birth certificates of deceased people could be obtained and then used to obtain passports, other documents, and so on. And likewise, the Portland spy ring, which is referred to in the Dead Doubles book and in the Christopher Andrew book. One point we've highlighted in our written submissions is that where that's mentioned in Christopher Andrew's book, he refers to MI5 putting in place a system that would be triggered by the KGB making applications to the records offices that might be used to found a quote-unquote dead double identity. And in our submission, the fact that there appears to have been some kind of system along those lines, and the fact that it appears to us inevitable that other agencies who wish to backstop covert legends or identities would have used the practice, that those are all matters which you should investigate, because you're faced with where did this come from? What was the justification for doing it? If the SDS managers were doing something that was just completely off the wall, obviously egregious, in the words of the Home Office, Home Affairs Select Committee, ghoulish, that no one in their position could possibly or should reasonably have done, then that would be an important finding for you to make. Equally, if they were doing something that was being done by those around them, those they were working with, and possibly even those they were working against, and that was the way a false identity was established pre-computerization, then that's an important matter for you to make findings about. Otherwise, you'll simply be saying, the SDS did it, other people did it, we don't know in particular who introduced it or formalized its introduction. And it also goes to the question raised by the Category F core participants about whether there were available alternatives. Was there another way of doing this which didn't trespass into the use of information about people who have died? So for those reasons, we say this is a matter you should go into. Now, I take your point, while you're not here to investigate MI5, we're not inviting you or suggesting you should look into MI5's use of the tactic or MI6's use of the tactic, but just simply whether or not it was a tactic that they used. What were the systems that they had in place with the registry to alert them to the fact that the KGB might be making a dead double application? Did they or would they have liaised with Special Branch or the SDS about the existence of those systems so that they weren't triggered by SDS undercover officers collating their legends? So again, that's another reason why we say further inquiry into this, which could be done simply by asking the agencies, could even be dealt with enclosed, but would inform you in terms of whether making a finding as to whether or not this was an aberration, an unforgivable, inexplicable aberration by a group of officers who'd just become cut off from reality, or whether it was something that was the way things were done at that time. So I think that's all I'll say about that third evidential issue. And then three miscellaneous matters, which I can deal with much more briefly. The first was just to complete a point that we'd first raised in our T1, P2 opening statement. And I think it was a point that we came to, having listened in particular to the evidence of Lord Hayne and the points that were being made, that the SDS was a monstrous waste of money, and that the resources would have been better spent elsewhere and would have reduced crime in the capital if they had been spent elsewhere. And it's simply just to collate the statistics for that, which are that more than 98% of Metropolitan Police officers were deployed outside Special Branch. So Special Branch itself is less than 2% of the attested strength of the MPS. Just focusing on Special Branch itself, more than 95% of Special Branch officers were deployed outside the SDS. So the SDS was less than 5% at any one time of the attested strength of Special Branch. And then standing back from that, more than 99.9% of Metropolitan Police officers were deployed away from the SDS. And so the relevance of that, we say, is that the focus that you have on the SDS can be distorting, because you're just looking at the unit, and it's easy to be distracted by that, and to fail to step back and see the wider picture. In our submission, when one looks at the whole apparatus of the Metropolitan Police, the SDS was a very, very small commitment, a series of antennae around the capital, taking in information that could be of use in relation particularly to public order policing, but also assistance to MI5 in relation to subversion. And it's if one were to look at it from a cost-benefit perspective, it's important to bear in mind how cost-effective and minimal the expenditure on it was, particularly bearing in mind that the Home Office covered its expenses. The second matter, sir, this is just very briefly. Mr. Barr has already touched on this. It's just the fact of the MI5 document that's now been disclosed in relation to information about children, which shows that police forces across the country were being asked to provide MI5 with information about quote unquote subversion in schools. And again, as with the use of deceased children's identities, the focus on what the SDS was doing in the abstract, without the contextual information about what others was doing, can be distorting. The fact that MI5 was asking for this information is strongly supportive of the fact that SDS officers thought it was appropriate to report it. Thirdly and finally, under this heading, sir, it's just in relation to HN 354, and it's just a point that we think is important in terms of setting the record straight. The second statement of Madeline alleges that HN 354 gave false evidence in his main witness statement. Of course, that's wrong, as you know, because you've seen the unredacted version. He did not conceal or obscure the fact that he sent postcards to former targets after his deployment. And just in his interest, him having been accused of having lied on oath, we think it's important to set the record straight about that. There's no criticism of Madeline. Of course, she hasn't seen the unredacted version of the statement. There it is. Before turning to Ms. Kilroy's points, it was just the final point we said in our conclusions was just an urging or an encouragement that there be more hearings in front of you, at least periodically, now that we're hopefully coming out of the pandemic and the restrictions that we've been operating under. Your next scheduled evidential hearings are in 2 years' time. And just as from experience of how the inquiry unfolds and issues come up, in our submission, it would assist to have periodically more hearings in front of you to discuss issues, or for the core participants to make applications or to request rulings, rather than the next opportunity we all get to air our concerns and our grievances is in 2 years' time. And I know that there are, of course, meetings between the inquiry legal team and the various core participant groups, and there's the opportunity for correspondence. But just being able to every now and then have a dialogue with you, sir, in our submission, we think would be very helpful. Just to take an example, the question that we raised about whether or not you would be, that we have raised about whether or not you'd be getting expert evidence from a psychologist, a behavioral scientist, the question we raised about expert evidence from a historian, they've been raised once every 18 months, and we haven't had a response. And it's very difficult in that situation to know why that is. So if we put a question to you, nothing comes back, or if it's just, well, I'm not going to do that. We don't know. Is that because you think it was a ridiculous and pertinent suggestion and you're not going to dignify it with a response? Is it because you think, well, there may be something in that, but I'm going to park it for a while and deal with this and come back to it? That type of thing in our submission, if we had more hearings in front of you every now and then, we could get to the bottom of things and make a bit more progress. So this is just a general suggestion, a general bit of feedback. Finally, sir, just to come on to Ms. Kilroy's analysis on behalf of the Category H core participants. What I'm going to say now is all very provisional. I've only had it since I think Tuesday afternoon last week, and I was only able to read all the openings at the weekend. So I just give you 2 sets of provisional thoughts. The first set is procedural in nature, and goes to, well, what's the relevance of this? And the second is more substantive, just in terms of the legal analysis that's being put forward. In relation to procedure, before we or any of the other core participants addresses this, I would submit it would help to have some guidance about what the purpose of the exercise is, and to which parts of the analysis are thought to be important and which parts are not. As things stand at the moment, as a matter of public law, all decisions of public authorities must be presumed to be lawful unless and until a court of competent jurisdiction declares otherwise. This is not a court of competent jurisdiction, and so therefore, as a matter of public law, there's not going to be any finding that it was unlawful to have an undercover police unit or anything like that. Also, in terms of the terms of reference of the inquiry, the legality or the lawfulness of what happened isn't an issue within the terms of reference. So what the terms of reference refer to is the inquiry identifying and assessing the adequacy of the justification, authorization, operational governance and oversight of undercover policing, and the selection, training, management and care of undercover police officers. In our submission, the adequacy of authorization is not and cannot be code for the legality or lawfulness of the use of undercover police officers. And if that had been meant, that the terms of reference would have said so, expressly. So we put that there as our first thought, first response in relation to the analysis as to what is the relevance of this, where would it go in terms of your report, does it fall within the terms of reference? Secondly, in relation to the substantive or the correctness of the analysis, we made brief submissions on the functions of police constables and police officers and the relevance of those functions to the work of the SDS in our T1 P1 opening. So that's October 2020. That's at part 3.1, and to the lawfulness of undercover policing at part 4.3. We referred to the report of the Poppe inquiry in 1833, within a few years of the establishment of the Metropolitan Police, where the prima facie lawfulness of undercover policing was affirmed. Of course, that was a parliamentary inquiry, but that would clearly be understanding on which the Metropolitan Police was working and would have been working thereafter. Beyond that, it would take us some time to unpick and respond to what's said in the Category H core participants opening, so Ms. Kilroy's submissions. But three provisional points occur to us. The first, and this is of particular relevance when it comes to the period we're concerned with at the moment, 1968 to 1982, is of course that the reliance upon and the reference to the Wilson decision of the Investigatory Powers Tribunal is inapposite, because that's a decision of a tribunal applying the Human Rights Act 1998 and the jurisprudence of the Strasbourg Court in relation to Article 8. So it's applying legal principles that didn't apply as a matter of domestic law in 1968 to 1982. It's also a decision, as Mr. Skelton has mentioned, that's based on concessions by the MPCC and by the Metropolitan Police. And in our submission, we'd go on to say that it's important to bear in mind that those are concessions made in the context of a particularly egregious set of facts, where it's evident the Metropolitan Police was trying to give just satisfaction to Ms. Wilson in terms of what it admitted, so as to make it unnecessary for those matters to be determined by the tribunal. So that's the first, in relation to the fact that Wilson, the decisions about the Human Rights Act, wasn't in force at the relevant time that we're concerned with at the moment. And then the second topic in relation to this is just as to what the law was at that time, 1968 to 1982. Essentially, the position was that the law was as set out in the Malone decision, that police forces, police constables, as Crown bodies and officers of the Crown, had power to do anything unless they were prohibited from doing it. This was a period, of course, before the reform of Order 53 and O'Reilly and Macman and the development of judicial review. It was before the enactment and entry into force of PACE, of the Human Rights Act, the Interception of Communications Act, the Regulation of Investigatory Powers Act, the Investigatory Powers Act, any of the Data Protection Acts, or the GDPR. And also it was at a time when the ECHR jurisprudence was very different to the jurisprudence now. So the Class and Germany decision comes at the very end of the 70s. So in our submission, it's unreal and unrealistic to, and ultimately futile, to spend time asking yourself whether the Special Demonstration Squad would have passed muster under all this raft of legislation and this ECHR jurisprudence that's come after it was conducting these operations, because that simply wasn't what those involved were faced with at the time. The domestic law was different. In our submission, they were clearly complying with domestic law. And then the third point to flag, again, provisionally here, is in relation to the logic of this analysis and where it really goes. So in relation to both the Article 8 Human Rights Act jurisprudence, but also in relation to the points that have been made in relation to tort law or the civil law, the logic of this analysis would apply to every undercover policing operation, to all the SDS operations that have been dealt with enclosed, and to all operations of MI5, MI6, and GCHQ. Particularly when one considers Article 8, there are of course two limbs to Article 8, the in accordance with the law limb. And we know because all of the legislation I've referred to, say for the data protection legislation, was passed to provide a legal basis for the exercise of functions so that the in accordance with the law limb of Article 8.2 is satisfied. Now, in the 60s, 70s, 80s, the legislation wasn't in force, so we know it wouldn't have met the in accordance with the law standard of Article 8, but that doesn't matter because Article 8 wasn't part of domestic law. The Security Service Act wasn't passed until 1989. The Intelligence Services Act wasn't passed until 1994. These were operations conducted just within a different legal context, and retrospectively asking yourself what the IPT or what another court would make of it now is in our submission just pointless. Things are very different now. The same goes in relation to the tort analysis, because what one then is faced with is, say, the questions that you raised about what might vitiate consent so as to render entry onto premises a trespass. Eventually you can look at the law of what constitutes fraud. Did the powers that the police had mean that this wasn't a fraud? But essentially what you end up doing is speculating as to what a court would have made at the time if faced with a tort claim alleging that an undercover officer has committed a trespass by going into private premises. And again, in my submission, it just becomes pointless and something that is not within your power or the terms of reference to determine, and that would, if it were the case that it was a trespass for an undercover officer to give a false identity and enter a premises, that would apply to every single undercover police operation, every MI5 operation, MI6, and so on. And so in our submission, it just becomes a meaningless, hollow exercise to say what hypothetically or counterfactually courts applying the law now would have made of what was being done in the 60s and 70s. But as I say, these are just provisional thoughts in response to the analysis, and happy to come back to it. It would help to have some guidance from you, sir, or from Mr. Barr as to which parts of the analysis require our attention. Otherwise, we're all just producing essays about the law. So those were my reasonably brief, I hope, submissions. And if there's anything else, I would just thank you for your time.
Commendably brief, thank you. Because you've raised an interesting and possibly difficult question, I will deal with what you were talking about last briefly, if I may. I accept, subject to what Ms. Gilroy has to say, the proposition that something that was not part of our domestic law at the time, as the European Convention on Human Rights was not, cannot determine whether something was then lawful. As from the 1st of January 2000, it can, of course, but it wouldn't apply retrospectively. That's when the Human Rights Act came into force.
2nd of October.
2nd of October is the wrong date. Thank you. I do think it is part of my terms of reference to look into the justification for undercover policing. I find it at the moment difficult to conceive that something that was not lawful under the common law could be justified as a police operation. Hence my worries about the two specific aspects to which I drew everybody's attention. I think your analogies with GCHQ, the Security Service, and the Special Intelligence Service are inapt for a number of reasons. First, GCHQ didn't trespass anywhere, but it did do things that the European Court of Human Rights has held required to be authorized by law. And of course, at that time, there was no law which authorized it. All that I accept. But likewise, the activities of the Security Service in obtaining Home Office warrants to interfere with telephones, or of the police to put listening devices on the outside of people's homes, all of which have been subject to litigation in the European Court of Human Rights. None of that is within, do I need specifically to address, because I am concerned with the lawfulness under the law as they existed at the time in domestic law. Subject, of course, to what Ms. Kilroy may say otherwise, and if she persuades me that that view is too narrow, then I will listen with care to what she has to say. But I do think that lawfulness under domestic law has got to be addressed. And it's only, as I see it at the moment, the two respects that I've identified where routine SDS activity might have been considered unlawful. So I hope that partly puts your mind at rest, partly focuses it, and leaves you with a question that I think in due course you need to answer. Now, can I deal with the other points? I would be perfectly happy to have meetings attended by all core participants to discuss issues as the inquiry goes along. You know the circumstances in which which was my original proposal, came to an end. I hope that those times are now past and we can engage in fruitful discussions. I'm not closing the door on that at all. Secondly, I am happy to have suggested to me reading matter that you think I ought to look at. And I'm very interested in the research that you've undertaken into the use of deceased children's identities before the SDS used it. I read that in your opening statement with great interest. And if you come up with anything more like that, please tell me. I don't intend at the moment to have psychiatric or psychologist evidence, because there is in fact a very clearly documented trail of what happened when it was realized that these problems existed. And I've read a great deal in the internal SDS management reports and in what psychologists, psychiatrists said about it. And I doubt that I need to know more about it than what I'm told by those reports and by what the psychiatrists, psychologists said at the time in the 90s and early noughties. But I have got to have regard to the need to report within a reasonable time and at reasonable cost. And engaging in all these interesting byways is going to delay things and cost something. And I'm at the moment, I don't see the need for it. But
it's helpful to a good illustration of the benefits of being able to speak face to face, sir.
Yes.
I mean, in relation to the first point and the question of lawfulness or legality, in my submission, there's an analytical issue here, which is, one takes the point, standing back, you would say, well, you can't justify something if it involved illegality. But that really just sort of imports the question of legality into the terms of reference in a way in which they're not there. When one talks about the justification for the undercover reporting, the justification in my submission must mean that the justification in practice, was there a need for public order intelligence? Was there a need or perceived need for intelligence about subversives? The justification for using the undercover method as the means to the ends is wrapped up in that. But to then say, well, you must remember that you can't justify something that could or would have been given rise to a liability, immediately in my submission runs into problems with Section 2, runs into problems with the scope of the terms of reference, and runs into the problems of drawing you into making findings that you have no power to make, that you're not competent to make. I don't mean that in the sense of...
No, I well understand the sense in which you're using it. I don't take it as an insult.
And therefore it's pointless, because the operation of the SDS as a matter of law, it was lawful. No court of competent jurisdiction has said otherwise. And as I say, going into these questions about, well, what would a court have made of a tort claim or a breach of confidence claim, inevitably that court would have been presented with different submissions about the relevance of the policing context and the justification for it and so on. So it just becomes, in my submission, I see the logic of saying you couldn't be justified if it involved illegality, but then that just opens a door into something that, in my submission, into a territory you can't and shouldn't go into. In relation to the second point, sir, we do think it would assist to speak to a psychologist or a behavioural scientist. We did take some steps to try and find one who might be able to produce a helpful report. It's very difficult to find one because those psychologists, behavioural scientists working in this field are engaged by police services and the security service. And so there's a difficulty with their independence, and B, they appear to be very kind of reluctant to disclose information or to talk about things publicly that might be seen as trespassing into sensitive matters. So we spoke to someone who was very helpful, who was recommended by one of our clients, but she just said she felt that it wasn't something she could assist with. But some of the things she said went further than what's in the papers from the 90s and the noughties, and I appreciate that they mirrored and they chimed with a lot of that. But a report, again, by someone who can then answer questions from all of the core participants and from your team, would be of much greater value. It wouldn't, in my submission, cost a huge amount of money, lead to any delay because it can be done in parallel with other matters, or require more than half a day of hearing. It would assist greatly. There seem to be issues to do with personality types, maintaining of boundaries, the suitability, and so on, and the effects of this type of deployment on people. And some expert evidence on that in our submission would assist you in making sound findings. The other difficulty with saying, well, I've got this material from the 90s with the introduction of psychometric testing and so on, so I think I've got enough there, is that we would say that before you produce a T1 interim report, it would assist you to have this information, because you're going to be making findings about the conduct of officers in the 70s without having, or before hearing or considering evidence about the stresses and strains they may have been under, the things that certain personality types are inevitably going to do in certain types of situation, and so on. And in terms of a fair set of findings about their conduct, this includes people who are no longer with us, Rick Clark and so on, in fairness to an understanding of what they did and how it falls to be judged. I'm not saying it's acceptable, but it needs to be understood in context. It would assist you, we say, to hear some expert evidence. You can ask questions, we can all ask questions.
And then I would find it impossible, would I not, to resist applications by those who have been affected by undercover policing to pay for them to have psychiatric or psychological evidence of an expert kind to support them. I'm afraid that I have got to do this within a reasonable time and within reasonable cost limits. And investigating something that the outcome of which has actually been demonstrated by facts is not a particularly good idea. Now, we can all read what happened to undercover officers in the lifetime of the SDS, and no one is going to suggest that it did not have an adverse impact upon some of them. Just as no one is going to suggest that their conduct, not necessarily the same individuals, but the conduct of undercover officers had an adverse impact on the lives of those with whom they interacted undercover. I think there is a limit as to what I can be reasonably required to investigate, and I think that crosses it.
Well, sir, I mean, I've said what I can from our side about that. I wouldn't say that the fact that hearing evidence about the impact on and the psychology of being an undercover officer means that you would then have to hear evidence about the impact on those who were affected by them is a reason for not hearing that evidence. And I certainly wouldn't say there's any reason why you shouldn't hear evidence about the impact on particularly the deceived women. There it is.
I do not wholly rule it out. Of course, I have to look at these issues as and when they arise in practice. And I do not wholly rule it out, but I'm at the moment unenthusiastic about it. Can we leave it there?
that went without saying, sir.
But my request for a reading list is genuinely meant. I also for any information that you can put in that you think may help. The non-states do this regularly, and I would encourage them to do it. The encouragement goes both ways. Please do so.
We'll do our best, sir. Thank you.
Thank you. I think that concludes business for today. If it does, we're drawing stumps 10 minutes early. Thank you.